What if I told you that a pair of lost pants once threatened to bankrupt an entire family for $54 million? Or that the creator of the universe was once summoned to a Nebraska courtroom and the judge actually let the case proceed? Welcome to the Legal Twilight Zone, where logic goes to die and the law is written by the unhinged. Today, we're counting down 22 of the most spectacular court cases that were so profoundly dumb, they forced the world to invent new laws just to survive the stupidity. The legal system is supposed to be a fortress of reason, a place where high-minded intellectuals weigh the scales of justice. But every now and then, a lawsuit comes along that's so weaponized, so petty, or so flat-out insane that the fortress walls just crumble. We're talking about the cases that turned judges into philosophers and turned common sense into a legal requirement. Grab your gavel, because things are about to get weird. The Mona Lisa of ridiculous litigation, the $54 million pants. In 2005, Roy Pearson, who was, ironically, a judge, sued his local dry cleaners for losing his trousers. Most people would take a voucher or a refund. Pearson demanded the GDP of a small island nation. His legal masterstroke, the satisfaction guaranteed sign in the window, was an unbreakable contract worth tens of millions. He lost, but the case was such a national embarrassment that it forced the system to write much stricter rules against frivolous lawsuits. Basically, a law that says, no, you cannot sue someone into the shadow realm over a zipper. Nebraska State Senator Ernie Chambers decided to sue the ultimate defendant, God. In 2007, he filed for a permanent injunction to stop the Almighty from unleashing floods and hurricanes. The crazy part? The court didn't just laugh him out. A judge actually heard the case. It was only dismissed because God couldn't be physically served a summons. Apparently, the court couldn't find a valid P.O. box for the heavens. It set a wild precedent. You can technically sue the creator in Nebraska, but the paperwork will get stuck in logistical hell forever. Robert Lee Brock, a Virginia inmate, tried to pull off the world's dumbest financial loop-de-loop. He sued himself for $5 million. His logic? By getting drunk and committing crimes, he had violated his own civil rights. Since he was in prison and broke, he demanded the state pay the damages to him. The judge dismissed it as a philosophical painting of a lawsuit. Now, it's a textbook example used in law schools to prove that you can't use the courts to pay yourself with taxpayer money for your own bad decisions. In 2008, the mayor of a Turkish city named Batman tried to sue Warner Brothers and Christopher Nolan. He claimed the studio used the city's name for the Dark Knight movies without permission, alleging it caused psychological trauma and a spike in crime. The lawsuit was so absurd, it became an international punchline before it even saw a courtroom. It established the unwritten "Don't Sue Batman" rule, reminding the world that picking a fight with a multi-billion-dollar superhero franchise is usually a one-way ticket to being roasted by the entire planet. A psychic once sued NASA for $300 million because the Mars Pathfinder rover was trespassing. She claimed to be a Martian ambassador and argued that the cold machinery was disrupting the planet's vibratory balance, which was apparently killing her psychic vibe. NASA didn't pay up. Instead, the case helped cement laws regarding space exploration and property rights, essentially confirming that being a self-appointed alien diplomat doesn't give you the right to charge rent on other planets. Ever wonder why your coffee cup has a caution contents hot warning? You probably think of the 1992 McDonald's case as the peak of dumb lawsuits. But history's version of the hot drink law actually comes from a case where a man sued a company because he spilled coffee on himself while driving with his knees. The court had to step in, not just to protect consumers, but to legally define that hot actually means hot. It's the reason every corporation now has to treat us like we've never encountered a heated liquid before. Let's talk about the man who sued a beer company because their commercials were false advertising. He claimed that despite drinking their beer, he was not, in fact, surrounded by beautiful women on a tropical beach. He sued for emotional distress and breach of contract. The court's ruling? Common sense. This case helped establish the puffery law, which basically says companies are allowed to exaggerate in ads because the law assumes the average person isn't dumb enough to think a light beer will turn their backyard into Ibiza. In a legendary display of main character syndrome, a man once sued his own parents for $200,000 because they threw away his collection of adult films and magazines. He argued it was a loss of valuable property. The judge didn't see the artistic merit. This case helped refine abandoned property laws, essentially ruling that if you leave your questionable collection in your parents' basement for years, they have the legal right to purge the house of your shame. There was a case where a burglar sued a school district after he fell through a skylight while trying to rob the place. He actually won a settlement because the skylight was unsafe. This sparked a massive wave of tort reform across several states. New laws were written to ensure that if you're in the middle of committing a felony, you lose your right to complain about the building's maintenance. It's the "don't rob and sue" act of common sense. A woman once sued a weather person because it rained on a day they predicted sunshine. She claimed the bad forecast caused her to catch a cold and miss work. She actually won a small settlement. This absurdity led to the meteorological immunity concepts, where the law finally admitted that the weather is chaotic, and a TV presenter isn't a wizard who controls the clouds. You can't sue the sky, and you definitely can't sue the person trying to guess what the sky will do. In the world of intellectual property, a man once tried to sue the moon. He claimed he had filed a declaration of ownership and that everyone else was trespassing. The legal response was a swift no. This helped reinforce the Outer Space Treaty, a real law that states no nation, and definitely no random guy with a printer, can claim sovereignty over celestial bodies. The moon remains public property, much to the disappointment of the guy who wanted to charge for moonlight. A fan once sued the NFL because a deflated football game allegedly ruined his experience as a viewer. He wanted billions in damages for emotional trauma. The court threw it out, establishing that being a sports fan involves an inherent risk of being disappointed by your team. You can't sue a league just because the game didn't go the way your parlay needed it to. It's now legally enshrined. Sports heartbreak is not a cause of action. A man once sued a dry cleaner for extreme mental anguish after they lost one of his socks. Not a pair, just one. He claimed the sock was an irreplaceable heirloom. The court ruled that the value of a single sock does not include the cost of a decade of therapy. This case helped set valuation limits on personal property, meaning the law now decides what your old laundry is actually worth, regardless of your sentimental bond with a piece of cotton. Have you ever heard of the sandwich law? It started when a Panera Bread sued a Qdoba, claiming that a burrito is technically a sandwich and therefore violated their "no other sandwich shops" lease. A judge had to legally define what a sandwich is. The ruling: a sandwich requires 2 slices of bread. Since a tortilla is a single wrap, the burrito was cleared. This is now a legitimate legal reference for food industry contracts. Burritos are not sandwiches. It's the law. A prisoner once sued the state because the crunchy peanut butter provided was a violation of his cruel and unusual punishment rights. He demanded smooth. The court had to spend taxpayer time deciding if texture preference constitutes a human rights violation. The ruling was a firm "get over it." This led to stricter prisoner litigation reform to stop the courts from being clogged with creamy versus crunchy debates. In 1991, a man sued himself for negligence after he hit himself in the head with a boomerang. He was hoping his insurance company would have to pay him for his own mistake. The court saw through the glitch in the matrix and denied the claim. This helped solidify liability loops, ensuring you can't be both the plaintiff and the defendant in a case involving your own lack of coordination. A woman once sued a movie theater because the popcorn was too salty, claiming it was a lethal weapon. She sought millions in damages. The judge pointed out that she could have, stopped eating it. This case helped strengthen assumption of risk laws, meaning if you buy salty snacks, the law assumes they will taste like salt. A man sued a haunted house because it was too scary. He claimed he was so frightened he fell and injured himself. The court ruled that the entire point of a haunted house is to be scary. By buying a ticket, you are legally consenting to be terrified. This haunted house law protects businesses that are literally paid to ruin your night. There's a law in some places that prohibits disturbing a bird. This came from a case where a man sued his neighbor because their pet parrot was mocking him. the court had to determine if a bird can commit slander. They ruled that since the bird doesn't understand the insults, it's not defamation. This led to animal liability clarifications. Your pet can't be sued for having a mean personality. A man once sued a hotel because the view of the ocean was partially blocked by a palm tree. He argued it was a breach of the aesthetic contract. The court ruled that nature is not a decoration you can control. This helped establish air and light precedents, basically saying you don't own the scenery outside your window unless you own the land the scenery is sitting on. In one of the most meta cases ever, a lawyer sued a law school because he couldn't find a job after graduating. He claimed the school misrepresented the value of his degree. The court ruled that a degree is an opportunity, not a guaranteed paycheck. This protected educational institutions from being sued every time a student fails an interview. Finally, a man once sued the city because he tripped on a cracked sidewalk while distracted by his own reflection in a window. He claimed the city should have made the sidewalk narcissist-proof. The judge dismissed it instantly. This case reinforced comparative negligence, a law that says if you're 100% responsible for your own stupidity, the city doesn't owe you a dime for your bruised ego.